Welcome back. Now we will like to know from Hasit sir how he has started the career and what all he can pass on to our young viewers, the students, to accordingly plan if they want to plan into arbitration career as a career. They want to pursue arbitration. What all things they need to know, understand.
Correct, correct. So the historical background, personal history background is that I saw my first arbitration in my third year of LLB. While I was doing LLB at GLC, my father was doing a large arbitration, and it was under the 1940 Act.
Okay.
I mean, and I saw like cross examinations and all that being conducted by him and also other side and all that. I mean, but that's the introduction. But then I had nothing to do with arbitration for a long time because I became an IP lawyer, intellectual patent lawyer. I mean, in US and all that. So that's there. But point is, like this is from a career or a skills viewpoint. This is part of a civil lawyer or a commercial lawyer's, like bouquet of skills. Okay. Because you'll get a client who wants to go to court. You'll also get a client who wants to go to arbitration. Based on the agreement they have signed or this thing, the choice has been made by client way back, when you were not in picture when the agreement was signed. 5, 7 years ago. So, as a civil litigation lawyer, I mean, you have to be ready to like understand this mechanism, and that's why the need for general civil litigation practitioners also to know about arbitration, because that's a demand which the client will make, that I want to go to arbitration. It's not your choice to decide a forum whether I should go here or I should go there. Because if it's an arbitration clause, even if you have filed a civil suit under Section 8, the court will transfer it to arbitration.
Right. Now, many of the young budding lawyers have this dilemma whether to jump into a specialization or keep it generic. So if he wants to pursue arbitration, should he stick to only arbitration practice or should he still have a generic practice as well?
A charge can be laid against me that I am a traditionalist, and because I come from a traditional civil litigation background, in terms of my training and career, I am a little bit of a biased advice. Is here that please spend at least 1 year in civil court, 1 to 2 years, whatever your time permits, and understand the mechanisms of the civil court. And please don't do it in a court where no trials are being done. Please do it in a court where trials are conducted regularly. Alright, it's the current if you then do international arbitrations, you'll find the mechanism to be in very contrast to what the evidence mechanism is. But just to see the evidence law in practice at some point and the whole adversarial litigation in practice, I think some time spent in civil courts will help. I mean, I'm sure a lot of people are going to shout that we are trying to create an ADR bar and we are advising people to go to civil courts and learn for a year. But I think there is some value in it, because people sometimes are in larger places where you can choose to specialize in arbitration. And most lawyers will tell you that it's your clients who decide what you specialize in, because they bring you certain specialized work. Your name gets well known for a certain reason, and this thing. And I have met very experienced lawyers. I mean, they say that we could do both civil trials and criminal trials equally well. I mean, but it's the clients who chose that I'll be a civil lawyer because they only brought civil disputes to me.
Okay.
Or they brought only criminal disputes to me. Although if given a choice, I would have loved to do civil trials or criminal trials both. I mean, or only even the other kind, which clients just don't come to me.
Thank you, sir, for the guidance to our young viewers with respect to career. You have shared your experience. But before we end this segment, I would like to know about the international arbitration scenario also, especially in recently Supreme Court of India entered into a MOU with Singapore
court. Correct.
Yes. So what are these avenues?
Correct. I think there are many aspects to the international arbitration, although the phrase is used very generally for many things. So one is international commercial arbitration. and there is a New York Convention, I mean, which governs international commercial arbitration, which governs the recognition and enforcement of international awards. So what happens is, let me give a simple example, that somebody in Italy sells something to a person in, say, Burma or Myanmar. Now both these parties, the Myanmar, if there is a dispute between them, a trade dispute, trading dispute about, let's say, the quality of goods or delay in shipment of the goods, the Myanmar party would not like to, by Myanmar, let's say Thailand, Thailand party would not, because like to say litigate in Italian courts. Italian party would think, why should I go to Myanmar courts, because maybe they'll favor a little local party, or who knows. That's the general impression of traders. This is from the business point of view. So they want a neutral court. Now there is no international neutral court where they can go to resolve these disputes. International, that court of justice and all that, it deals with treaty problems. They don't deal with this kind of trading problems. So this mechanism essentially has come in the late 20th century, middle of 20th century, 56 So for this purpose, that international commercial disputes should be solvable by a neutral person appointed, and maybe a neutral choice of law or any choice of law, whatever the parties have decided. If they have chosen law of Thailand, laws of one of the parties, let that be. And let the seat be of arbitration, where the arbitration be conducted separated from it. Law could be governing law of one of the parties. Seat could be some neutral, which is neither this party or neither that party. Also geography, now we have digital and all that, but earlier travel was required. So it had to be somewhere in the middle, physically. So a lot of people chose London, like trade disputes in Europe and everywhere and somewhere other country. London was a neutral territory, and that's why London is known as the home of international commercial arbitration. But there is also one aspect of international treaty arbitration. So that's known as ISDS, and it relates to investment treaty disputes. So a lot of bilateral investment or multilateral investment treaties exist, whereby protection is given for investment, because suddenly, like the national sovereign countries, have national policies or pass national laws to nationalize things. So foreign investment done in this thing could, be expropriated by that government through that nationalization or selling it off, etc. So the investors need a mechanism. So that is through this investment treaty arbitration, and there are various mechanisms to deal with it and all that. A permanent body to administer that for the countries which are part of that or which have voluntarily chosen that mechanism is ICSID. There is an office in Washington. It's an arbitral institution like others, and it administers this institutions. And going back to in the first part we talked about arbitral institutions, they also administer international disputes. In that there are two parts. One, every law sort of will have an international mechanism for international. So part 1 of our act actually deals with international arbitration seated in India.
Okay.
So the award that comes up is in that aspect. And then there is the second part of our law deals with, award which may be seated anywhere in India, parties may be anywhere, located, the governing law may not be in Indian law, anywhere, anything. But if it could be brought into India for execution part of it, if there are assets in India or an Indian court can execute that award in some manner, then it can be. So the award under a New York Convention can be executed in multiple countries at the same time.
Okay.
So part of the assets are here. So let's say one multinational company has a factory here in India, one in Italy. So the award which has no connection with these countries at all, neither parties, neither dispute, neither governing law, nothing can be brought into enforcement into this country through that treaty that was signed. And India is an early signatory to that treaty.
Oh, that is very.
But India has put in a reservation called reciprocalness. We do it only countries reciprocally who allow this for our.
That's fair.
So that's a reservation which India has put.
That's fair also.
I think so.
But this gives a lot of comprehensive view towards international arbitration. And anything else you would like to add on to this international aspect with respect to maybe rules, how they differ from India?
Yes, so I mean the procedural part is what I would like to bring to notice of people, and also that procedure now is slowly being brought into domestic, and more, domestic arbitrations are being run on this procedure. Is a procedure where the burdensome proving of documents, oral evidence pretty much is the same. There is an examination in chief and crossing, but these are known as limited time arbitrations. In the sense, total amount of hearing time is calculated in minutes, and in that cross examination has to be completed. So very limited time for cross is there by the choice of the parties, consent of the parties. Also, all documents are read into evidence. I mean, in domestic arbitrations, this can be done because you have flexibility, right? Parties or the arbitrator can decide to do it. So, all the burdensome mechanism of proving the signature, proving the contents of the document, application for secondary evidence, all can be given go by.
Okay.
And usually, why this happens is that when the transactions are only between two parties, one side has sent a letter to you and you have sent a letter to you. What is the point of disputing that letter? The other side, putting the burden that, okay, you are propounding this document, so you prove the signature and you prove, like the contents of the document and the truth in it and all that. That I think is a far stretch mechanism for this, because our evidence law is common for civil and criminal, just like US. I mean, England has different laws for both these things, civil and criminal. So, and that's why arbitration developed much faster there as compared to other countries, I think. This is my personal viewpoint. There is no need to bring those rules here, because they to prove something beyond reasonable doubt, the criminal standard, you need that kind of, anybody brings a document, how should the court believe in it? But that's not a requirement here between transactions between two parties, right?
Yeah.
I mean, true. If I say I have sent a letter and I have record to show that I have sent you a copy, it means that you have got a copy.
Yes.
In a rare case, it was not received by you. But let's say you got a copy and you have written a reply to it, yet you say I have not got the letter. How does, I mean, that's ridiculous, right? I mean, so arbitration cuts through practically all these aspects of it. International tribunals don't even bother with these small things. I mean, as such, there is a mechanism to challenge authenticity of the document, production also of the documents, by something called a red fund schedule and all that. They've invented a completely new method. But now this is being brought into domestic arbitrations, so we must get used to it and learn it quickly.
Okay. So we got quite a, as I mentioned, comprehensive view, a detailed view about not only domestic arbitration, international arbitration as well. And thank you so much for joining with LawCharcha, sir. And it was indeed a very great experience interacting with you, learning many aspects, new aspects of arbitration. I'm sure our viewers are benefited by that. And I must say that in my introduction, I have given you only the glimpse. Now, by the end of this interview, you must have understood the depth of this gentleman's knowledge. And you visit his LinkedIn profile, you will understand that the amount of experience and the amount of knowledge he carries with him, it's huge. He has a great fan following on LinkedIn also. Please follow him on LinkedIn. You will also benefit a lot. Thank you once again, sir.
Thank you very much. This is simply, thank you Rishikesh for inviting me on LawCharcha. But this is simply a knowledge sharing exercise. I mean, by which the great amount of body of knowledge that exists and efforts taken by people like Rishikesh to bring it to a much wider audience. I think those things must be appreciated, and good luck for all your future interviews.
Thank you, sir.
Look forward to hearing those.
Thank you.
Please follow Rishikesh's channel. Press the bell icon, as they say.
Thank you, sir. Very kind.
Thank you.